Welcome to a new episode of the Life Science Get Together podcast. Today, we are talking about one of my favorite topics, digital business models, especially about the question, is it possible to patent digital business models? I looked into this topic way back into the 90s when I was a student at the university and working for a research organization. And the answer in the 90s was quite simple. It's not possible to patent anything around digital. It's not possible to patent code. When I got interested in 2015 in digital health, I looked into this topic a second time and came to the same conclusion. It's not possible. So when Astrid reached out to me with the idea of looking into this topic a third time, to be honest, I thought, yeah, well, probably I will come to the same conclusion. It's not possible to patent anything. But I agreed that it makes sense to at least look at it the third time. So when we had the preparation call with Professor Wurzer, how should I say it? I think it describes best if I say I had a life-changing, game-changing, enlightening revelation during this call and realized how little I know about this topic. So I'm very happy today to have Astrid Wollert and Professor Wurzer on the call. And especially thank you very much, Astrid, that you had this great idea so that we get a chance to learn more about the reality of patenting digital business models. Astrid, over to you.
Yeah, thank you very much. It's really great to be on this patent podcast episode with you. So just a brief introduction for people who don't know me. I'm a partner and head of research at Falcon Digital Investments. So we've been previously known at Untitled Ventures. So we're currently undergoing a rebranding there. And this is where I'm on my day-to-day activity. I source, screen, and analyze potential investment opportunities in the blockchain space. My background, however, is very heavy on IP strategy. And by the way, it's a very common misunderstanding that VCs will only look for a higher number of patents in an investment opportunity, or at least the ones that know about IP will actually rather look for a sort of realistic and reasonable mix of all their sort of asset classes that are out there in this space. So really a mix of those specifically tailored to your business. And IP strategy doesn't necessarily mean like, oh, patent all of it. It's actually a very big strategic field that basically evaluates the use of a range of IP instruments. So patents are part of it, yes, but there's also copyright and the licensing strategy that goes with that. There are also trademarks and also very notably trade secrets. And when it comes to patenting, most of us will be aware that in order to patent the technology, it must be novel, it must be inventive, it must have an industrial application, and must be of a patentable subject matter. However, there's a lot of confusion out there when it comes to patentability of software, and even more so when it comes to patenting digital business model, which, I need to be very honest, was also news to me until a few months ago when I first had a call with Professor Wurzer. And I was actually really fascinated hearing about this, but it immediately sort of highlighted to me a great danger in there for a lot of startups out there, but also for established companies, to be honest, what this topic actually means, what implication it has for their own IP strategies. So it's a really pleasure to welcome Professor Witzer here with us on this podcast and to hear all about this exciting topic.
Yeah, thank you very much for having me here. My name is Alexander Wurzer. I'm professor for the role of IP within the digital transformation for more than 15 years now. And yeah, what should I say? From my perspective, it's funny to think that especially digital business models could not be protected via patents, because that's, so to speak, the cornerstone of so many IP strategies, which can obviously be seen and are analyzed and are documented and published. And we have trainings with the IPI help desk in Europe, in China, in Latin America. We we teach that with the European Patent Office. So I'm professor at the Center for IP Studies at the University of Strasbourg, which is the central education institution for European patent attorneys. And to a certain extent, I'm a little bit shocked how big that gap is between what we do, so to speak, in the IP academic world and what is at the end outside in the real world, where really the decisions are made, where the money is made. How big is the gap between the two thinking styles? And I'm very happy and thankful for the idea from Astrid Wollard to bring me together with Mr. Soschner, and that I have the opportunity to explain a little bit what's going on in that, maybe strange IP world, because I guess it's very, very important that the different communities, and here is the life science community, understands a little bit better that it makes sense to make at least a little deep dive in that topic when it comes to decisions, business decisions, and investments, and to real issues.
Many thanks for the opening words, Professor Wurzer. I have one question at the beginning, as I started with it's not possible to patent anything around the topic digital. How is the reality when we look at digital life science? What's going on in that space on the patent side?
Yeah, so I have received today the latest figures from the colleagues from the EPO, from European Patent Office. And there is a fascinating study, which I will later on put on the IP Business Academy, which is a blog on the protection of digital business models, which we run from SAPI. And the latest figures are tremendous. So the patent applications on the fourth digital industrial revolution are skyrocketing, and they overall, so it's unbelievable. They are really disconnected now to all the other technologies, how they go in the height. And the problem which we have is not that we have not sufficient or not enough patent applications. This is enormous. We have a rising figure here from 45% over the last 3 years, and it goes more dynamic now than ever. That's not the issue. The problem is that the patent applicants not coming from Europe. So Europe is not really represented in the patent applications compared to how European companies, for example, in the life science era, typically represented in overall technologies. So what we see is a tremendous lack of patent activities in digital fields, and especially at the protection of, let's say, economically relevant digital objects like use cases, customer journeys, user experience, business models, apps, all these economically important digital objects. So we have here a huge lag compared to what's America, as a United States-based companies filing in Europe, and especially also Asian companies filing here in Europe.
Let me ask one question to dig a little bit deeper into the reality of patenting a digital model. How does that work? Because I got several times the information, it's impossible. You can't do that. So how, when I have an idea, where should I start? What is necessary to file a digital patent, or what are doing the US-based and the Chinese companies differently? What route are they going? Can we please talk a little bit about the basics?
Of course. So the starting point is that many people even don't understand what a business model means. And they are confused they confuse the term business process with business model. So that's the starting point of the misunderstanding. And unfortunately, we have a kind of business process patent in the United States. And once they hear business and patent, they start to be confused. Okay, so first thing is, I'm not talking about business process patents. I'm talking about patenting business models. So what is a business model? A business model describes how you run your business. We have two parts in general. Okay, we have the resource part, which reflects the resource-based view. So your value chain, your resources, the way how you create the customer benefit, or let's say the value proposition. And we have the market side, which tells us which market position do you have. So how do you deliver anything? Okay, and how you communicate your unique selling proposition. So this reflects the market-based view. And typically a business model is the trick how to create something which somebody wants and you make money with it. So, so you create a profit. And so you have a balance between that both sides. And a digital business model now uses digital technologies on some of these four sectors. Okay, so the value creation, the core competencies, 1, 2, 3, the market position, the way you deliver, and 4, how you communicate. Maybe in one of these sectors, or in more than one sectors, or in all sectors, you're using digital technologies. That's why we call it a digital business model. And as soon as you use digital technologies, you use technologies. So, and what is a patent? A patent is, let's say, a new combination of solving a technical issue with technical means. That's it. So that means, let's say you collect. So now and now we need that description. We need the question: what is your trick? Why is this business model different from others? Which technologies do you need? Do you use? Which data do you have access to certain data? How do you get the data? How you mix the data? How you process, analyze that data to deliver something which is now different from anything else before? So how you do optimizations, how you do suggestions, how you improve things, yeah? And that are all technical questions which are solved with digital technologies. So, and when there is any keyhole, let's say a certain access to data, okay, even when you are not allowed for the moment, maybe you're not allowed to collect that data, but you could patent it, saying once you are allowed, or once you have that sensor, or once you have access to that data, you would combine it in this and that way and deliver this and that value to your customers. So, and the way how you do that, once it is critical in terms of when I patent that, nobody else would be able to process the data in that way. So then you have protected via patent your business model. So it's the digital technical implementation of the critical aspects how you make profit in your business model. That means other would be able to do something, let's say, similar. It looks similar, but finally they have not the critical competitive advantages which you patented, and so you are sustainable and the others not. And this is exactly how we patent the way how we make business.
This is really fascinating, but I'm wondering, for example, for a young upcoming startup, it's sometimes even difficult to just look for any kind of patented technology out there in patent databases like a SpaceNet or PatentScope or Google Patents, whatever is out there also as free resources. But how do you actually start even looking for a digital business model?
Yeah, that's again a big misunderstanding. That means many people, especially, let's say, technological people, right, coming out of the university, are full of that technological knowledge and totally driven of the way of their technology. Okay, and the first thought is, how can I patent that? So, but that is exactly the opposite what I'm talking about. Once you become digital, you become complex, you become big, you have extreme big systems which are extreme complex, you have interdependencies, and so that means when you start with technology, that leads you to nowhere. And that is exactly that kind of patenting what we see out of misunderstanding, frustration, I don't know. People patent meaningless, ridiculous technical solutions for technical problems which definitely not exist or purely artificial. So that's not the way how you should do it, okay? What you do is you come from your customer. That's a business model. That means you need a customer. And the customer should feel anyhow that you do something for him or for the customer. So, and that means you analyze your use cases. So why are you able to realize that use case? And what makes that different from others? So that means we have a wonderful example. I guess everybody can understand that, okay? So I don't make it too technical to understand how that game works. And that's maybe the most important thing. It's a game, okay? It's nothing real. As long as you fulfill the legal provisions, and as long as it is physically or chemically, so on natural science, realizable, that's it. It is not necessary that you do it, that you can do it, that you want to do it. The cornerstone is that you want to have a forbidding right against third parties. So, and the next thing is you have to understand your use case. So, and then you have to protect a use case and nothing else. So, and what I try to explain to people is, so how do you patent artificial intelligence? Let's say you have anyhow a life science business model, and within you have an optimization or a process routine which runs with artificial intelligence. So the typical technical approach is now, where come the training data from and which algorithms do they need? So no, you even don't mention artificial intelligence when you want to patent it. Okay, we have a wonderful example at the EPO. It's the inventor of the year from 2019. So this is a guy which comes from Norway. And the Norwegian, they have these farms for salmon. And they have a problem with parasites. And these parasites lives on the skin of that salmons. So, and he patented a method and a gadget, okay, which is a laser cannon, which he dumps into that farm. And this laser cannon is able to identify on a swimming salmon, okay, they're quite fast. On a swimming salmon identifies this pesticide, this parasite, focus the cannon on it, and makes a precise shot, which is focused 1 or 2 millimeters ahead of the skin of the swimming salmon to kill the parasite. So this is a patent. The question is, how are you doing that? Okay, which software could solve that? It's very simple. The inventor of the year is explaining you this is machine learning, and there's only an AI solution is able to do that. But this is not written in the patent. For what? AI is like a screw. It's simply a technology which works. Nobody is in doubt that it works. Okay, so you don't have to explain that. Explain me what you're doing with it. What are you doing? What is the use case? What makes you, what differs you, what is here new, what is inventive, how you apply AI. Yeah, and don't describe AI. And this is the way how you should think. It's not the technical question per se, especially when it comes to digital solutions. It's a combination of existing solutions which makes you unique, and you are able to provide a totally new inventive use case which creates benefit. Don't mention people, okay? Just mention technologies. So here we don't mention the salmon itself. It's just that we want to kill that parasite, and that's it. And then you have your technical teaching in terms of what we need to declare in a patent. That's it. But you won't never come to such a patent when you start with your AI.
One question from my side, to just reiterate if I got it right. So my thinking so far was, when my team has an idea, we work on it, we find a solution, we produce the solution, we bring it to, let's say, minimum prototype stage that it really works. And then we have a look on the patent side, if it's possible to file a patent. But when I'm listening to you, it sounds to me like that's not necessary. So we just need to have the idea, and we can already start looking into on the patent side, because you mentioned don't mention the AI. So is it really so that we just need to sit down and put the idea together, and then we can go? We're good to go.
Okay, so nowhere in the patent laws on that globe is written that you have to do what you're patenting. Okay, for what? Yeah. So you can say the early laser patents, the early microwave patents. These guys were not able to produce a product which works really. Okay, the early lasers, that was a laboratory experiment. Okay, not a product. And even that, we have many patents where the guy who patented is not able to produce that, to do that. For what? That's not the point. So as long as it is doable and you convince your examiner that it can be done, that's it. Of course, it's a game again. And don't confuse it with reality. And that means, for example, okay, to make it as clear as possible, we have at the moment big discussion out there on how to apply 5G. So I would say 50% of all thinkable 5G application use cases are already patented. How can you do that when 5G is not existing at the moment? Of course, you imagine what you could do once you have such a network with such an ability. That's it. And you have certain advantages because that kind of characteristic is or will be available, and out of that you get your new and inventive use case solution based on a 5G network. Whether that exists or not doesn't play any role here. That means it is, I would say your procedure is not bad per se. You can do that if you have the time, if you are not in competition. As soon as you are in competition with others, and as soon as these others understand that we have the first to file principle. First to file means the one who is the first who thought his things through and was able to write it down will get the patent. And that means you should be as fast as possible thinking the digital understanding which kind of exclusivity print, how that works. Look at Ping and Good Doctor from China, a unicorn, one of the biggest insurance companies in the world, but at the same time, one of the biggest patent applicant on that globe. And they think the things through and make the patents. Whether this is doable, it is legal, this is not the point. As long as you fulfill the provisions of the patent law, you will get your patent.
Let me get it straight in my mind. So it basically means what I need is an investor with a deep pocket on one hand. On the other hand, I need a smart team who can think things through to the end, especially on the use case side. And I need a smart patent attorney. And we don't need to put any other work in it than coming up with a concept. We don't need to put it in reality. We can start filing patents when we have a thought through concept. Is that right?
You described the business model of intellectual ventures, which is one of the biggest patent funds in that world, which has a funding of, I guess, 6 billion. And this is exactly what they're doing. Yeah, and you describe the business model from Signify, the former Philips Lighting. They go use case by use case. They analyze that. They make big shows, invite people to think what could be done with light in the future. They patent it and then they license that out. Okay, that are the biggest. So they have right now. They have so it's a case study on IP Business Academy. So it's well documented. Look at that. It's a huge licensing program. They have more than 1,000 licensees. So nearly each and every LED manufacturer on that globe is licensed at Signify. Because when you want to realize a certain use case, you will find out that it is already patented from Signify, as long as you use LEDs for it. So so this is a business. So this is how the game is played, how the big boys play it. And when we go to the startups, I don't think it is necessary always having that deep pockets. The deep pocket game is for the big boys. But once you are smart and clever, and you are able to think things through before others, you will find the classical keyholes. In terms of this is a central position. Once you have that, a certain area is not anymore accessible. And that's what you're looking for. That's the patent which has really value, because it is a cornerstone of doing that business. And typically it is a way of getting data, or a certain data model, or the way of using data. And again, whether you have access at the moment or not is not the point. As we understand now, it is enough to think a world in which this data would be available, and it is physically or it is simply doable to get that data. And now explain me which kind of use case would you realize with that? And this is per definition new and inventive, okay? Especially because the data isn't existing so far. Yeah? But when it is clear that it could be done, then it is like a screw. Okay, I accept. We could produce that data. And now tell me what you could do with it. How can you improve? How can you suggest? How can you optimize? Whatever, reduce transaction costs and so on. And I guess this is really the chance. When you think in the right way, you can really create valuable patents which are at least a bargaining chip in the future, that you say, but I have exactly that patent. Yeah. For example, IBM right now is suing Airbnb in the States for what? Based on an 18 years old patent. 18 years old patent. And this patent describes a method to display on a digital platform individual advertisement. So 18 years ago, that was AnyNet. That wasn't the today internet. Yeah. And they had never dreamed of a platform like Airbnb. But Airbnb is exactly doing that. It's a use case. And they do that, and they have their IPO, their initial public offering, and they negotiate for 5 years now. And now IBM says, no more. Yet now we go to court. And that means it is important to understand what will happen, what could happen, and which kind of exclusivity right or forbidding right of exclusivity position I would like to have in such a digital transformed ecosystem.
Yeah, I think this is also something that is really, in terms of strategy, very important to consider for a lot of software companies. For example, I work a lot with open source software companies or open source projects, and they are of the firm belief that, oh, we don't want to have anything to do with patents because they're evil and bad. We want to keep free and open innovation, and we can only achieve that if we don't patent things and only open source things, which is a very strong misunderstanding, right? Because basically, it's basically to keep it really open and free, you also have to have a patent strategy to guarantee this sort of freedom and openness to other companies.
Exactly. That's a big misunderstanding again of the patent law or in general of intellectual property. I explain it in that way. Okay, I'm living here in Munich, in Schwabing. So it's one of the hot areas in Munich. So we pay here, I would say, around 2,000 euros for a square meter estate. And let us assume on the other side of the street is an estate where there's no building on it. Okay, and a pedestrian comes to me and I say, you know what? I think you could use it. Just use it. Nothing is on it, okay? No fence. So you can just use it. So sooner or later, this guy will ask me whether I own that estate or not. Because only ownership gives me the right to motivate a third party to use that estate. That's very simple. As long as I'm not owning it, it's ridiculous that I invite somebody to use that estate, this piece of land. Of course, it is ridiculous. So, and it is the same thing with intangibles. When I have not made sure that I'm owning something, I cannot invite people to use it. Oh, I can, but I'm not sure whether there are other ownership rights on it. Okay, so people invest in a totally unsecure situation, and sooner or later somebody comes, has a piece of paper in his hand, it's a patent, and said, "Thank you very much for developing that solution, but I am owning it." Yeah. So, and that means behind all big open source projects is also a big fund, a patent fund, which helps to keep that thing free of third-party rights. That's very simple. So open innovation is behind Linux. And this is a multi-billion-dollar fund, which is which buys patents, which offers free licenses to third parties, to users, and make sure that nobody can come up and say, I have a Linux patent, and that's why your Linux implementation is infringing my patent. So it is very important that it makes, for a lot of reasons, it makes pretty much sense to offer a free usage, yeah, to say, I want to invite others to use my solution, and I don't want to collect money, but I want to have a certain value exchange, okay, and I want to, I want to create a de facto standard, and lots of strategies can be behind that. But first of all, we have to make sure that we can do that from a legal standpoint, and that means we have to clarify the ownership on that thing.
We have questions from the audience. That's really fascinating. I will hand the mic to Ksenia Takistova. Welcome to the show, Ksenia.
Excellent. The question was really at the very beginning when Dr. Wurzer was starting to distinguish the business model in Europe from the business method in the US. They still sound very similar to me. Can you clarify?
Okay, I try to do. We have that wonderful patent in the United States of swinging a swing. Okay, it's a method to clean a room. So this is definitely not a business model. This is just a way of doing something. A business model describes first on the resource-based view or on the resource side which kind of resources you need. And it describes on the market side how you collect your money, how you deliver how do you deliver value, and how you communicate that value, and how you get the money for it. So, and the difference between the costs which you have to create the value and the money you get for the value which you are delivering, that's the profit, and that is based on that business model. So swinging a swing, don't explain me that. Okay. So the question is, where lies the value in? Who is paying for it? How is that paying done? And in addition, when we talk about digital business models, and I'm not saying that you can patent every business model. I'm saying you can patent digital business models, because for a digital business model, you have to explain me where is the digital technology and what is the digital technology doing. Okay, so let us assume you have that cleaning procedure. Okay, so it's not long ago I worked with a company which is in the cleaning business. And for example, in the cleaning business is one thing extremely important: reducing the amount of soap, of cleaning material. So, and they for example have a technology which combines the question how to use the soap and how is the floor reacting, and from what is the floor, what is the material of the floor, and which kind of cleaning material do you need, and to optimize that, and not just for the single procedure. They do that in a learning curve for many different rooms, many different floors, many different materials. So, and there lies the optimization in, and this is a cost reduction effect, and that creates the value, and that is patented.
Thank you.
Welcome.
I have another question in my mind when we go a little bit back to the startup world and how it looks like. So my traditional way was we start working, and somewhere in the future we file a patent. As far as I understand you from this talk right now, is when I continue on this path, it means that anybody in the world, when they look at my work or the work of my team, they can start filing patents. They don't need to have anything produced. What's the reality then for the startup in the future? I mean, you brought up the Airbnb case. Is that happening very often in Europe, that smart European guys start working on something, and on the left side, the United States guys just looking at Europe, and the Chinese guys are looking at Europe and start filing patents? Is that really happening? Or is it just in my mind?
No. That's one of the biggest issues here. That people who think that digital objects, apps, to take Shazam, for example, it's one of my cases in my lectures. I ask my students, what would you say? Is Shazam patented? First reaction, no. So second reaction, when Alex is asking that questions, maybe yes. So, and then how many patents? Okay, this patent portfolio, which was bought from Apple for more than 400 million, has more than 200 documents. So it's heavily patented. So yes, what happens, and this is the problem, people who think that cannot be patented think third parties cannot have patents. Yeah, and as I try to explain, this digital implementation of business models is the battlefield right now. And that means the ones who have understood how that game it has to be played, yes, they start with patenting and do all the rest later on. And that means that you should not think that you are the first one who has a certain idea to implement a business model. That means what we call freedom to operate, yeah, is nothing what you get just because you are creative. Okay, freedom to operate is hard work. That means you have an idea how to do something, and then you start to look, and that should be your first assumption. Okay, where's the patent? Who has already patented that concept, that idea? And once you found that guy, you can be lucky. Okay, maybe you have 5, 6, maybe you have hundreds of patents which describe that. Okay, hundreds is hard, but let's say, so then it was too generic. Okay, let's say you have really a smart idea and you see a bunch of patents, 10, which are in force. Okay, and they describe exactly what you wanted to do. It's good. That's good. You know the state of the art now. And now you start to think, how could we do what we want to do to go out of that patent? Yeah, that makes you smarter and faster. And that's good. But you should not assume, okay, that's the, so to speak, the worst thing what you could do is that you are the first one, you are alone, and that cannot be patented. That's not a good idea. Waiting, so to speak, with this patent question for later. So once you want to run a digital business model, the first thought should be which kind of patents are here involved. And then you solve that problem first.
Do we have already actually some experience or data on how defensible these business model patents are, especially the ones that don't really have much substance to them, but are just sort of some concept, some idea? Because if you think about therapeutics, normally you have to have a sort of baseline data set where you're like, okay, there is some effectiveness or something. So you don't just easily get it by convincing that, like, okay, it will work somehow. So do we have any data on that already for these kind of patents?
Of course, so we have here at the regional court in Munich, we have quite a lot of disputes. And we can learn a lot when we understand that a Canadian company, Research in Motion, the BlackBerry company, sues an American company, an US-based company, Facebook, at the regional court in Munich for the infringement of a digital patent. And then WhatsApp has to be reprogrammed. So that tells us something where a Canadian company which wants to sue a US-based company goes to enforce the patent, because WhatsApp is similar at the whole globe. So it's cheap in Germany. It is very sophisticated. We have lots of cases. We have most cases in Europe, and we have very experienced and well-trained judges here. And that's the reason why companies around the globe like to come to Germany and to enforce their patents, especially the digital patents, because typically digital solutions are globally. So once I have a successful app, it is run on computers, and as long as it is also implemented here and done here in Germany, then you can enforce your patent here. But I agree you said you need patent attorney, yet you need good patent attorneys. Yeah, so a patent attorney is not a good one just because it's a patent attorney. It's the same thing with professors. It's the same thing with doctors. Yeah, it is a profession. So, and within that profession, you will find guys who like this very abstract, very so to speak, unconcrete, not you cannot see it, you cannot touch it, you cannot smell it. It's a conceptual thing, which is the nature of the digital solutions. So, and when you are a trained mechanical engineer, a chemist, a pharmaceutical, whatever, when you have that classical scientific education, you don't like this kind of abstractiveness. That's normal. And so it makes sense. It makes sense that you look for a patent attorney who has a certain experience and also a kind of emotional coupling to that kind of questions. That makes a lot of sense. So don't assume that just because somebody is a patent attorney, he's also in favor for digital patents, or he likes that doing that. That's typically not true. And in addition, quite often these kind of things are that complex that these patents are relatively expensive in terms of it is something different of having a mechanical embodiment and just wrapping a patent around that. So it's just describing what I see. Compared to working out for whatever manufacturing execution system or a software as a service system, a patent for it. Yeah, that's typically more work, and therefore it is a little bit more expensive. Yeah, that's true. But in general, this is what you would do. You use your patent attorney, this legal experience, and find out how do I have to formulate the issue that is technical, yeah, and that I solve a technical problem.
We have a few questions coming in from the audience. Let's start with the first one. It's Chama Natekwi from Symptoma Austria. Chama, here is the mic. Hi, Chama. Good to see you.
Hi, Christian. Thanks for having me. And thanks, Alex, for this wonderful lecture or webinar. I have a really basic question. I'm almost embarrassed to ask it, but so as one would essentially patent an idea, what if the idea has been already made public in a movie, on a conference, in a scientific paper, on a blog, anywhere? Can you still can you defend yourself and say, well, this is not patent infringement because before you filed your patent, this idea has already been public knowledge? Or what are we talking about? Because if you're talking about ideas, I think there's so much that has already been published.
That's a wonderful question. Thank you for that. Because again, a big misunderstanding. Again, big confusion. So let's say it in a formal way, okay? An idea cannot be patented. So I want to offer in a restaurant individual water to people. Yeah, nice. This is an idea. Okay, so first of all, explain me what is individual water. Okay, then explain me how would you do that? How would you produce? So that's, by the way, a real case. Yeah. How would you create a personal individual water? What should that be? How are you doing that? How can you identify the preference? Okay, what means individual? That means is it because he's looking angry, or what creates the preference for a certain water? Maybe a certain illness, or the combination with the taste of wine, or I don't know what. But as soon as you explain me the implementation of that, it starts to become a patent. Yeah, it is patentable, and it's not anymore an idea. Now you explain me how you would do that. What I talked about a little bit earlier on AI, I say, be careful what you are explaining. Yeah, maybe there are aspects which are not necessary to explain because everybody agrees that you can filter water. So maybe this is not the cornerstone of your idea. So the cornerstone is that you create H2O, which is not normal water, which is purest water, and then you fill in again the ions and CO2 and carbon and so on, and manufacture that water. And that is something different from, I saw in the movie that somebody had the idea to offer individualized water. Yeah, that is an idea, and that is public. And by the way, it cannot be patented. But when you have a concrete way how you realize it, then you can patent it again. But and not again, you can patent it, okay? But be careful. Yes, when something is really in public, let's say in a Mickey Mouse cartoon, the way how a rack is lifted. That's it's a wonderful example out of the education of patent attorneys. It's done with balloons, and Mickey Mouse is doing that, or Donald Duck is with his nephews is doing that. Then it is it is published, and you cannot patent that method because simply it's known. It's public. It's not new. Okay, because that cartoon shows you a technical implementation of the idea how to bring that up again on the surface of the water.
Okay, so let's have a borderline case. Maybe it's a borderline, I'm not sure. Let's talk about Star Trek. Let's talk about the artificial doctor with a tricorder scanning patients and coming up with what's wrong with them and what they need and healing them. Mm-hmm. So, I mean, it's not only, I mean, you can extend on what an idea is or not, or it's not, but there's a clear method, there's a clear use case. There could be a business case behind that.
So now you explain me the way how you differentiate. So you get anyhow a signal. Okay, so, and now explain me which kind of signal is that and what you're doing with it. And you have your patent. Because what we see in Star Trek is obviously just an idea. We don't know how it works. And Gene Roddenberry, the author, we have this beaming. Okay, this relocation of objects. Physically, no problem. Yeah, why not? We have the atoms. Okay, we bring that to, we have the information. Bring the information to another place and use the atoms from there and pull it together. The only problem is the Heisenberg uncertainty relation. Okay, and that tells us, the Heisenberg uncertainty relation tells us that you cannot determine the place and the impulse at the same time fully accurate. So once you be better and better in the one, you lose the information of the other. So, and Gene Roddenberry invented the Heisenberg coils, which are deep down in the ship, okay? The Heisenberg uncertainty coils. And some of the, at one of these conventions, a guy asked, "Dear Mr. Roddenberry, how do they work?" And he said, "Thank you, well." And this is exactly for what you don't get a patent for. Well, when you can explain me how it works, you will get your patent.
Okay, so this is why I was asking, because previously I understood that I don't have to explain how the AI is working, in this case, how the beaming is working. So
moment. What I said is AI is an accepted technology. Yeah. It's like a screw. You don't have to explain each and every screw. As long as it is accepted technology, it's okay. And we are not in doubt that an AI can solve the problem of identification of the parasites and all that things which has to be done here. We are not in doubt that that could be done, and so you don't have to mention, and that's not the trick. The trick here is using a laser for solving that specific problem and shooting the parasites down, and don't killing the salmon, by the way.
Yeah, so I'm really sorry to follow up just one more time on this very same topic. So the AI has not been accepted, let's see, as a technology back when the Star Trek movie has been aired and published.
Now that's an interesting.
So it was back then only an idea.
Okay, we have the patent law comes from the late 19th century. Okay, so in Germany it was from 1870, and I guess in Austria it's more or less the same. And most patent laws come from that time. Okay, Industrial Revolution. And nowhere is a concrete description what technology is. So in terms of accepted technology. Or you can say, when you look around you, I don't know where you are, but despite of that, just look around you, what you see. These colors, these chemicals, these surfaces, these objects, whatever you see, these materials, nothing had existed 150 years before. That means we have an evolving technology term that we adapt what is accepted and working technology continuously. And yes, you're fully right. Things which we don't understand today and we cannot use natural forces to realize it, in 20, 30 years, that will be accepted. Yeah, why not? But I would say for a very concrete and recommendation to real life people with real life problems, I would say my recommendation is that you should understand your use cases and try to patent out of your business model and concrete implementation of your use cases. You find out which kind of patents you want, okay? And you don't need any Star Trek for that.
Okay, thanks.
I'm a huge fan of Star Trek. Let's come to the next.
Of course.
Yeah, it's
Who is that not?
all movies are great. All movies are great. Let's come to the next question. It's from Malte Könner. Welcome to the show, Malte.
Thank you, Alex. Thank you, Alex, for this fascinating insight. It's interesting that American and Canadian companies fight in Germany over digital patents. And yes, I fully agree with you that some of digital patents for the technological part of a digital business model can be used for that. Choosing Munich as a venue, however, there may be more reasons than you mentioned. And I think one of the very important reasons is also that we have this injunction gap in Germany. So I admit this is more like a comment and it has nothing to do with digital patents, but that can be a very important reason why they chose Germany. I can explain what the injunction gap is, but I don't have to. Okay. Thank you, Alex.
That's the pity with the patent attorneys. Okay, now I get, yes, that could be a reason, of course, no question, no doubt about that. But we have here, the audience here is, I guess, more interested on the basics. And yes, it's patent law is very complex, and it is based on every country, and so. Yeah, very, very specific details, but I try to give a general recommendation, and this general recommendation to our community is that don't start with technical thinking, start with what is the cornerstone of your business and your use cases, and try to get that patented.
Excellent.
Thanks, Malte, for your question. Let's go to the next one. The next question comes from Ronald Zieger. Welcome to the show, Ronald.
Well, thank you for this really interesting and easy digestible information. I have a question regarding how to start a guided process within a law attorney or in a patent attorney, and how to find a certain specialist for each technology or environment the company is working in. Thank you.
Okay, so first of all, ask the person. Okay, so typically that helps. Maybe you know that after 18 months, you have access. So the patent is published. So you should simply ask that guy for some examples of the work. In addition, you can make your own retrieval. So you just go into the database as Basnet or whatever, and look for your specific technology or idea, and look for the guys who patent that. Yeah, the representation representative. So you find experts also in LinkedIn. So I think that's a very good way. So when you make, for example, when you check what Malte Kölner, who is a patent attorney, is saying and publishing via LinkedIn, you can find out whether he is an expert in that field. And so simply because he is discussing that and he is publishing on that issues. So it's the same procedure as you would try to find out who is an expert in a certain research field. Okay, so somebody who is not working there, somebody who is not publishing there, is not speaking there, is most likely not really an expert in that.
Okay, thank you. Second question. So there are more than just one patent attorneys out there, and to find the best one for a specific business model, it's like to find a needle in the hay. And when I think to life science, there's so many self-designated persons out there. Everyone is a specialist. Is there any trusted third party where to find a contact who will be trustable for people they're new to the law attorney business or to the IP business? Is it IP Austria?
I don't know. I have a strong intention to say, go to the guys who studied my program in Strasbourg, but I don't say that. What I'm saying is it could make sense that, for example, the office where this guy works, so typically you need a combination. Yeah, you would need a guy who has a certain experience in life science, and also you need somebody who understands the digital components of it. Yeah, and a very good combination is when you have that both resources, for example, in one office or even in one person. Yeah, so and you find that out of the patents which are already published, and you can check that. And I'm absolutely sure that when you talk with that patent attorney after 50 minutes, you know whether this guy is understanding you, and I mean really also from an emotional point of view, understanding you and can help you, or you are talking with windmills, and then I would stop it.
Thank you for the answers.
Yeah, because at the end, welcome. At the end, you need somebody who is fighting for you. Yeah, he's really he has to be needs a certain passion for that, and this person should fall in love to a certain extent to your idea, should have to fight for it, that you both get that patent, and it is a fight. Yeah, I don't say that it is easy. I never said that. I don't say it's not complex and all that things. And so you need really a guy who is with you and wants that this becomes a success for you both. And then I would say you have somebody which you can work with.
As you said, I think it's very easy to find a specialist under every second stone, but a life science specialist maybe is a digital business model illiterate, and to find both of the topics in one person, or at least at one IP bureau, will be hard to find. But yeah, we will take a look, and thank you.
I can also relate to that from my experience when I was working still for Oxford University Innovation. We had a number of patent attorneys really enlisted on a number of different cases across disciplines, and you could really see huge quality differences in kind of who was better and who was maybe not so good, and who was really, really bad. And I think one piece of advice that Professor Wurzer also gave about looking into what kind of patents someone has already written, and sometimes also just looking through the publicly available information, how they were actually fighting this case and how many applications were actually granted or rejected in the end, can also give you a little bit of an indication how experienced these people are also in that respective field.
Thank you.
This was exactly not what I wanted to say. Okay. I agree. And to a certain extent, that can be an indicator, the granting rate. But take into account that it is not always the objective of getting a patent granted. So it is an absolute normal legal strategy to file a patent for something where you know that this won't be ever patented. For what reason? But there is a patent application that is published. And that means nobody else could get that patent. Nowhere on that planet. Yeah. So it can be, it is really a strategy to get, for example, a freedom to operate for something very specific, that you say, okay, we file it. And we make sure that it is in the database, and we make very clear on the title, on everything, it will be found. And it is our documentation that whoever will try to get the patent, we already published it, and so it can't be new. Yeah, and this is one of the provisions to get a patent. So that I just want to mention that again, things become complex. Yeah, I just want to mention that granting rate for other reasons too is not that cornerstone. It is a hint, of course, when a guy never get a patent granted. He has a problem anyway, but you should be a little bit careful with that, because sometimes the patent attorneys are not the ones who decide that. They are just the instrument to realize a certain strategy from their clients. Okay, just to mention, to be fair. Yeah.
Thank you.
Yeah, I think it's the entrepreneur's job to find the needle in the haystack, and I completely agree. I mean, whenever I hear the term attorney, people should be aware of that they need to find a man or a woman. I also learned that women are great in fighting, who really fights for their clients and not against their clients. Let's go to the next question. It's from Marcos Kaufmann. Marcos, welcome to the show.
Yeah, thank you very much for the very insightful talk. I guess from my point of view, I have a little bit of experience on business models and innovation in manufacturing, which is a very traditional sector. And what is absolutely gobsmacking is the lack of understanding, as you said, of what business models are to begin with, but also the lack of understanding of what IP really means, and how to protect it and to profit from it. So I guess I would like to ask if you have any suggestions and any insights regarding how to develop some of this practical knowledge around IP protection for digital business models, and also how would you go about building some of that knowledge into the curriculum for multiple disciplines? People in social sciences, people in computer science and engineering need to know more about these topics in order for us as an overall society to benefit from it.
Okay, thank you for asking that questions. I did not pay you for that, but that's really great because that gives me now the opportunity to starting my advertisement. Okay, first of all, you see the logo. There is this IP Business Academy, which is active on the internet. It's a website from my university, University of Strasbourg, and also it's on LinkedIn, very active, IP Business Academy. And there are, well, tons of material available, case studies, teaching material, lectures, everything free of charge, okay? And in addition, of course, you can walk into one of my certificate courses, but that costs money. But what we also offer is a free of charge training program from public funded, where we explain how to create digital objects to make them patentable. And so I can only recommend to you, get in touch with me via LinkedIn, for example, and we can organize such a free of charge training program.
That's great. Thank you very much.
Welcome.
That's good to hear. So thanks for the commercial, for the advertisement.
We do whatever we can to improve the knowledge on that issue.
That's a very good idea. That's a very good idea. And I will post the links to your LinkedIn profile in the description of the podcast later on. So you should not be surprised when some people reach out to you. Let's go to the next question. It's Thomas Lutz. Thomas, welcome to the show.
Yeah, thank you. So maybe I missed it earlier, and forgive me if I did, but what are actually the best examples of already patented and accepted digital business models? Because I did a quick search for patents of business models, and a lot of them seem either to be never accepted or later retracted because the applicants didn't pay the fees actually. So what are some really great examples where you could look at and see how they did it, how they described it? That would be interesting. Thank you.
Yeah, you missed more or less the whole show, right? I really tried to explain that it is not a good idea to describe a business model for patenting it. I never said that. So maybe that's the worst practice, okay? No, that doesn't work. First of all, it is the digital implementation of the, let's say, technical issues which makes this a business model unique. That is what you patent. And I can tell you, you won't find that when you look for it in terms of, I can read the patent and I understand the use case. I can show you patents, and we do that. For example, for the gamification from Nike, okay? A wonderful use case. And so gamification means that you motivate people to have a challenge with each other, and that you can have an exchange, and you get a certain award. And the whole thing, the whole gamification issue is patented by Nike. So of running, yeah. When you make gamification of something else, you can patent it again, but then the implementation of that kind of gamification. What I said is you can observe the pattern. So first of all, you can download some of my case studies, okay? And there is described, so from the fleet management from Hilti, or one of the newest from Ping and Good Doctor, the digital patient journey. So that's fascinating what Ping and Good Doctor is doing there. And we describe that and we publish it, and just read that. Then take the examples, okay, and then read the patent. And after you understood the case, the business case, the business model, you will understand why this patent protects a cornerstone of that business model. But when I show you the patent and you don't know the business case or the use case, it's just it's a patent like thousands others too. That's the trick, so to speak. A digital patent can only be analyzed and understood typically once you understand already the business case. Standalone, it's a technical problem, which is also a technical issue. And sometimes it takes really time to explain people why this specific technical issue protects an use case. Because it's not a one-to-one, so you don't describe the use case per se. Typically, what you're doing is you find out what are the technical tricks, the issue which has to be solved, and that is patented, and this is the keyhole.
Okay, thanks for explaining.
Welcome.
I have a question. You mentioned the gamification, that Nike filed a patent in gamification of running, if I understood it right. So does that practically mean, I love running, and I love computer games. And sometimes I think, why not put out an app on the market that gives rewards to runners, which basically is a sort of gamification. Would that mean if I pursue such an idea, that I should expect, if in case the idea works well and delivers money, that Nike one day might knock on my door and say, what about a license deal? Would you like us into the game?
I would assume that just say shoot it down. Close it. Okay. Yes, you should expect that. And for an example, let us assume you want to improve on running shoe. Okay. You would never start with the idea to put a sensor in it and to use that data then for a competition with others. Never ever. This is maybe even the shoe is not that perfect with the sensor that it would be without the sensor. Okay, so you make the shoe not better, but this sensor gives you data for the use case of gamification. So that's a wonderful example that you would never come to the idea of putting a sensor into a shoe as long as you just want to improve shoes. But as soon as you start to think about a use case, you understand that this is first an invention which can be patented, and second, that it opens you the accessibility of a gamification use case. That's exactly what I'm saying. But as long as somebody just thinks about running shoes, for what should I integrate and sensor in it?
I have many ideas. Data is. I mean, training data. It's everything. I mean, Runtastic and
but then it is again. Then you think about the training. It's not the shoe. The shoe is not improved by improving your training. That's the next use case.
Okay, that's true. So basically, what does that mean now for our startup companies here in Europe? I think many of them are just working on things. It sounds to me, what would your advice be to them at this point? What's the critical thing they should start looking at when it comes to IP rights?
The first and most important thing is thinking about use cases, business models, user journeys, customer journeys. You should not start with technology when you think about patents. That's not helpful. That's the first thing. The second thing is, as soon as possible, it can't be too early, think about patents. So try to understand what's going out there. Don't assume you are the first one. That's the most important understanding. And this is not bad. Yeah, the other way around, this is wonderful, because that means somebody made already the work to describe that. Maybe it is a granted patent, maybe not, whatever. But you will find a way how your business model implementation is already described. Okay, and then start to work. Use your creativity, use your imagination, to improve that, to make it better, to make the use case better, to make the customer experience better, to make to create higher value, and that will lead you to a really good business model. And that's the general recommendation.
We have another question coming in from the audience. It's coming from Kira Borkert. Welcome to the show, Kira.
Hi there. Do you hear me?
Yes, welcome.
Thanks. It was a great talk. Very important for us. We are a startup. And actually, I'm not going to tell you right now, but who would I go to? Because, I talk to so many people, and always I got the answer, no, you're a software as a service business, your idea, it's not patentable. So now I have the idea, and I learned a lot. I know exactly that it's really a new thing. It's a new customer experience and a better one. So what would be my next step? To look for what? An attorney in Austria, or should I contact you, or how do I continue?
Okay, so simply because I would like that this is finished sooner or later, write me an email. Okay.
Okay.
And I will try to take care. My first reaction as a teacher is you should get informed. So that means we could, for example, do for you or your company this free of charge education part. I can send you material. And of course, we will find a partner attorney for you.
Great. Thanks a lot.
Welcome.
You're welcome.
That's my job.
Professor Wurzer, thank you very much for your time. And
I don't want to stop it.
I have so much more questions in my mind, but I think that probably also other people would like to speak to you after 5:30 p.m. Or are you good to go for another half hour?
No problem. I'm sitting here very well.
Okay. Then I come up with my questions. Let's go a little bit back to that situation with the United States and China. It sounds to me that they are further advanced in their thinking of filing digital patents than the Europeans. How far advanced are they really? How active are they in that field?
Mm-hmm. Okay, so the point is we should have to define advancement. Okay, what means advanced? It is a fact that in the United States and in Asia, there is not that kind of engineering and scientific background and kind of thinking of mindset when it comes to IP. Okay, so you can say it in that way. They are much more relaxed on that. In terms of, I would say, they are this when you talk with a typical Austrian or German engineer, and it comes to patents, you will hear that only rocket science and only really important breakthroughs can become a patent. Okay, so like Mr. Bosch, Mr. Siemens, Mr. Daimler, that are the people who received patents because of their groundbreaking inventions. So, and that's a kind of mindset. Okay, that means a patent is a kind of inventor award. Yeah. And unfortunately, to a certain extent, what we do at the EPO is that with this inventor of the year, we even foster that. Yeah. But from a US perspective, and also for many Asian countries, it is a legal tool. This is business. Yeah. And like for many things, you have a certain triviality barrier. Okay. So you can say all the simple business models are already done. So you need a little bit more sophisticated one, yeah, to be successful. So you have in many areas, you have a certain triviality barrier, which is there. But once you are beyond that, you can get your patent. The question is, which one do you want to have? And who you want to forbid something, and how deep your pockets, and all the questions. But not that you have to be a rocket science engineer. That's not. And so it is simply that they have a different perspective on that legal instrument first. Second, especially for the US guys, legal issues are a cornerstone of making business. Yeah, that's sometimes for European people that is strange. So even when you have a negotiation with an US business guy, typically the attorney is sitting next to him. Yeah, so having a legal issue, so making business is to a certain extent always having a legal issue. Yeah, so that's not the way we think about that. So typically Europeans say, yeah, we have that legal framework, and now let's make business. Yeah, so it's a separated area, so to speak. And the next thing is that that US guys and Asians have a strong asset orientation, especially US. That means they think in assets. So this patent has to make money because it's an asset. Asset means productive property. So where's the product? How can that thing be productive? And you come and start with a licensing thinking or whatever. It's an asset. Yeah. And it's not an award for an inventor. Yeah. For who made a rocket science invention. So, and finally, and that's around the globe true, that not the patent law has changed, yeah, because of the digital patents. What has changed is that different people using the patent law in different ways. That means not the engineer who is proud that his machine works now wants a patent for the working mechanism of that machine on which he worked for years, yeah, Rudolf Diesel. Now, a software guy thinks in a totally different way. So the coding, what we would call the production, yeah, or the to make really the thing happen, it's boring. It's boring work typically. So what is fascinating, thrilling, where is the intelligence in it, is the architecture of a solution, is the way how that could be implemented. So they think on a completely different abstract way, and they patent exactly that. So they look on the world because they are used that the world for them is infrastructure. Yeah. So that a computer, so they don't care about computers. That's just a machine. Okay. I'm looking for the architecture of my solution. So this is a totally different way of thinking compared to our IoT thinking. So I have a physical object and then I bring it into the cloud. Yeah, this is IoT thinking from the physical world up in the cloud. And these guys thinking exactly the opposite. They live in the cloud, and all what is necessary to realize and use cases infrastructure. So look at the patent portfolio from Spotify. Yeah, you won't find there patents about loudspeakers, how to make sound, or that's infrastructure. It is there. They have patents on the question, what part of a song should I present to Christian that he will like that sound? Not just which song, which part of the song is critical for Christian that he will like it. So that's a wonderful patent. and that doesn't care how you're listening to that, which kind of loudspeakers, of earphones, I don't care. So, and the opposite is Sonos. Sonos is thinking from loudspeakers and to bring that loudspeakers into the cloud. That is, I know it's a US-based company, but that's European thinking. Yeah. So, and when you are natural born in the cloud, yeah, you write different patterns and you use the pattern in a totally different way. Like you make software, you understand the concepts, the architecture, the implementation. That's enough. The rest is infrastructure. Like the AI for the Salmon guy.
No, I absolutely agree. I think we have to change our mindset a little bit, or shift our mindset more to the thinking of the United States guys. I think China was very successful in that. And I was very often thinking about why is Tesla, for example, what makes Tesla so valuable compared to the German car makers? Very often I hear the argument, Tesla is producing cars, Volkswagen is producing cars. Volkswagen, I think it's worth 80 billion or something right now, if I got it right, and Tesla no for 300 billion. So I think what you said, Europe is product thinking, and we're putting product to work, we're producing products, whereas the Americans are more into the idea world, use case world, business world. You defined it very nicely as a cloud thinking. Maybe the value of Tesla is the patents they filed and the data they generate. And this opens up a new range of ideas how to do business, because basically when you look at the patent as an asset, not as a price, there are so many ways to make money with that. One thing is to put it into reality as a company, but this is very expensive. But the other thing that you mentioned is licensing. And it looks like the Americans are probably going into that direction. Do you see it similar?
Yeah, of course. What I said with the different ways of thinking, so bottom up or top down, yeah. Can you see exactly it's exactly the difference between what Tesla is doing,
yeah,
and what the typical German car manufacturer is doing or are doing. What we see here in Germany is that we start with a car, and then we ask the question, how can that car goes into the internet? Okay, this is IoT thinking. Okay, then you have the physical object, then you have the layer of sensors and actuators, then you have the layer of communication, then you have the layer of analytics, and you end up with the layer of services. So, but it starts with the, a long time. It's not that long time ago that for a typical European engineer, the question, which kind of business model runs your company, was to a certain extent unethical or not discussable. What does that mean, business model? So I'm an engineer, I'm creating a wonderful product. It's fascinating, it's world class. And all what I'm doing is I'm giving that to a third party, to my customer, and my customer gives me money for that. Where's the issue with the business model? I don't understand that. And it's not that long ago that when you go to a, let's say, typical European engineering company and talk to the CTO or CEO and you talk about business models, that was not discussable. Yeah. And even the reason, why should we talk about that? So, and what we learn with the digital transformation is that one of the cornerstone is how to make a smart business model around your idea and around your product. And yeah, you can go to Miele and ask 300 engineers, are you really sure that people want to buy washing machines? I don't believe that. I accept that your job depends on the fact that people are buying washing machines. But you don't think that once somebody sneaks around the corner and gives the people a new deal, I don't know which kind of deal, but at the end, it fulfills the need of having clean clothes in my in my room, in my cupboard. And once this comes, you can go with your washing machines wherever you want, because people don't want to buy washing machines. They want to have clean clothes.
Yeah.
So, and we saw that in so many cases that now people start, CEOs, CTOs start to become nervous. And this is exactly what we can learn from Tesla. They don't want to build a car at the cornerstone. So what they are looking for is, how can we create use cases to coming from A to B and using a car for that? But they are totally open to the question, how could we realize use cases? And yes, to a certain extent, we need something which can drive, and yeah, but it is infrastructure for realizing use cases. And once you think in that way, you come to a multitude of solutions. And only a few of them have this IoT logic. Yeah, and that's one of the reasons why we need that big screen in the car.
Yeah.
I have another question, because sort of the whole discussion got me to think about, is there actually a place for trade secrets in digital companies or digital innovation companies? Because the past years we've always been saying, well, if you can keep it a secret, if someone can't really easily sort of reverse engineer your product, then it's better to keep it secret, because otherwise if you reveal it via a patent, then there is a risk that they could sort of find a way around and maybe sort of get your business in there. So if we think about these business models now, and if we think that, okay, we've got now our trade secret, but someone else comes up with a similar idea but just puts a patent on it, then it could well be that suddenly from today to tomorrow, my IP strategy was keep it a secret, which was actually pretty stupid in the end.
Naja, that's a very general question. And there is no general recommendation. Okay, that's the typical lawyer recommendation. It depends. So my learning over the last years was that people overestimate the effort getting patents, and they dramatically underestimate the effort to keep a secret. Yeah. That means, especially when you grow, that's extremely difficult. So I've worked, for example, with Airbus, and till today, the Chinese are not able to produce a commercial airplane. That's a fact. Even when Airbus is manufacturing the A320 in China. So I would say they did their job very well, what means proliferation or knowledge transfer so far. But it is a huge effort, okay, to make sure that every worker only knows what this worker has to know, and so on. Yeah. So what I want to say is trade secrets are yes, it's a very common tool, but it is very complex. It is hard work to manage that. Once you do it right, it is very good, yeah. But it is first of all not very bad or nearly not enforceable. So when somebody is able to copy you, you are copied. On the other hand, coming from a business perspective, having an enforceable patent, yeah, which describes not an individual single technological solution, which describes a business model and the access to a business model or business or use case. This one thing, okay, use cases typically come from the customer, otherwise it wouldn't be a use case. And the customer are taught, they learn something, how to do something. Okay, for example, for a long time, it was normal to do this thing, okay, slide to open, yeah, to use your thumb, and you describe a certain trajectory on the screen of your mobile phone, of your smartphone, to open the smartphone. to switch the status. So that was one of the most valuable patents on that planet. Why? Not because it is rocket science, because the people were trained, they were expecting that this happens. That's the reason why Samsung infringed it. Not because Samsung is stupid or they are not clever to bypass or whatever. No, the customers forced them. Okay, we call that a dominant design. So James Utterbach coined that terminology. And when your use case becomes the dominant design for certain user group and you have patented that has a huge value. So people think, when you think in that way, so first of all, a product is not an object. A product is a bundle of argumentations. And this bundle of argumentation fits with the expectations of your customers. So when you then are able to offer use cases which teach your customers, and the implementation of these use cases is patent protected, and the argumentations are unique and patent protected, that's where you want to be. And that's, one of our case studies is the Thermomix, and whether you like it or not, but it has a reason that a relatively small, a comparable small company like Vorwerk dominates the market of these smart kitchen machines. And this is not that Kenwood, Bosch, these huge companies are stupid. No, it is simply that the Thermomix and the way how the Thermomix works and the use cases which are realized are the dominant design how to do it. And that is patented, and that it cannot be simply bypassed by others because customers expect that. And this you can say you patent customer expectation or the realization of the customer expectation, and you teach the customers. And this is a sustainable competitive advantage. And I would invest in that.
We have another question from Chama. Chama, welcome back.
Yeah, thanks again, Christian, and thanks, Alex. So the other side would be freedom to operate. And you just showed on, well, if you have a concept and a use case, a user journey, and so forth, first, what you should then do is to actually think about patents, and which first, of course, means freedom to operate. And then I was surprised because you said, well, if I find that for this very use case that I had in mind, there are 6 different patents in place that in somehow would infringe my my business idea, that this would actually not be a problem in terms of, at least you know now that the infringements might be there. But the question would be, is there a general tactic or how to approach it if there are many patents that could be infringed, and how do you differentiate? How do you design in order to not infringe the patents and still can actually pursue with your business idea without having to pay like the money of a bully that just has a patent, like the IBM Airbnb case.
Yeah, especially Airbnb should have been a little bit more careful.
Okay.
Okay, so again, it's a huge question. Okay.
Okay, so they make me the question smaller, because if you're talking about Airbnb and IBM, and you say Airbnb was not careful, would Airbnb have had a chance 10 years ago in order to not infringe the IBM patents back then?
Of course. Typically, you choose once you make your homework, then you choose whether you want to infringe or not. And I would say the assumption is that behind a certain business logic, behind a certain business mechanics, like offering individualized advertisements on a business platform, the assumption should be that this is patented. Now that's what I really try to convey here, that as long when you do something and you can put digital on it, yeah, your assumption should be it is patented, and then you start to work. That's the point. And you need help, of course. Yeah, it is not that you can everything. You need a tax consultant. You need somebody who helps you at the sales department or with the sales or whatever. You need an R&D department and R&D help maybe. And so you should have help in the IP world, and you need that. And your investors should know that this is a cornerstone of a strategy. And my experience is that even in big deals, yeah, we had such a deal 2 years ago in the automotive industry. A big deal. It was a multi-$100 million deal. So. And you would expect that they have enough money on both sides to pay the best lawyers and the best accounting experts. It turned out that all these guys oversee the major problem that the product, why that company was bought, was not licensed. It's an infringing product. And they have never tried, it was a connectivity product, okay? And they have never tried to get a license for it. Yeah. So what I'm saying is that maybe the one had no compliance, IP compliance, and the other had no due diligence, no IP due diligence. And what I'm saying is the more intangible, the more digital the things become, the more important is it to make the homework on the IP side. But unfortunately, what we see out there is that the practice is the opposite. Yeah, that people think these digital things have nothing to do with IP, like in the open source discussion some minutes ago. So my recommendation is that investors, startups should make their homework, should look for support to make sure that on the IP side, things are done and safe. And working with bypasses, with assumptions, which are based on misunderstanding and especially no education. Yeah. So you wouldn't do your tax on your own for your company because it's too complex, typically. Why should you do your IP work on your own when you have no education on it? That's all what I'm saying.
Okay, thanks.
Okay, so it's hard for me to keep my children quiet. So it's like a bomb, okay? And so the the pressure, yeah, it becomes higher every minute.
I fully understand that.
I have to assume that sooner or later this bomb explodes there.
Yeah.
And so I would like to stop here. Maybe when there is an interest, we can do it. I don't know, half a year or a year later again, or something like that. When
would be a great thing. I think there are many things to discuss. I really like the points you made about different mindsets, and I think we have to implement that better in Europe. I would like to thank you very much for your time and extending the time frame we have set for half an hour. It's really interesting to listening to you, and I can recommend everybody go to any seminar, webinar of Professor Wurzer to learn more. Thank you very much, Astrid, for putting that together and to have you on the team. It's great help. And thanks also to everybody who was listening. Have a great evening.
Thank you.
Thank you very much. Bye-bye.
Bye. Thanks for listening. Please share the podcast and make sure you've subscribed. Have a great day.